Good evening, viewers. My name is MC Chaka. Welcome to another edition of Legal Hour. Tonight, we've got a very interesting topic to discuss. And of course, I'll be here with my usual guest, lawyer Thomas Beyebenwo from City Law Solicitors. Tonight's topic is very interesting. We're going to talk about the 10 and 20 year-long resident rules to indefinite leave. And of course, to remain in exceptional circumstances under the root. So for people that have been in this country for over 10 years, 20 years, the route that you can obviously follow to achieve your permit or your indefinite leave, this is what we'll be talking about. We'll be discussing, even if you've been in this country without legal documentation, using somebody's documents to work, assessing the NHS through somebody's documentation. I mean, every route we're going to talk about it tonight. So it's very interesting. So make sure you get your friends, your family, and everyone on board, because tonight's topic is something that will benefit a lot of people, most especially from the African continent, from Ghana, from Nigeria, wherever you are in Africa, or wherever you're listening to me right now. If you've got a family, if you've got a relative and living in the UK and the person has not obviously establish or obtain any document or legal right to remain in the UK, this is an opportunity for that person to listen and know the route they can use obviously to get their right to live in the UK. So please make sure you share this program. This program is proudly sponsored by City Law Solicitors. They've been our backbone from day one, and tonight, of course, they are sponsoring the program. We'll be sharing our link, our Facebook link, very soon. But then also, we've got our radio or live City Media Radio. If you go to Modern Ghana, their broad section, City Media Radio will be there. And you can access or you can get this program right from there. So please make sure you share as soon as you get the link, and make sure that you get people on board to benefit from this program. I'll be back with my guest. He's getting ready. So please stay tuned. Don't go away. I'll be right back. Please stay tuned. Viewers, welcome back. We live City Media, and I've got my guest lawyer Thomas Beyebenwo from City Law Solicitors, looking smart as usual. Welcome to the program, lawyer.
Thank you.
And how are you doing today?
Oh, it's always a pleasure to be in this studio. I'm doing very well.
Oh, great, great. I know you've had a very busy schedule today, but then thank you very much for coming upon all your busy schedules. You still find time to come and speak to viewers and listeners. So thank you very much for obviously imparting your knowledge and educating the public on policies and what we need to do to help ourselves legally. Thank you very much. So Leah, we've got a very interesting topic tonight to discuss. Tonight's topic is 10 and 20-year route for long-term indefinite residency or exceptional circumstances to live or to remain in the UK. So I know there've been a lot of updates on this because a lot of people are very concerned whether they can get permit to live in the UK after they've been in the UK for 10 years and 20 years. But then so when we talk about the 10 years rules on a long stay, what is actually the meaning of that? The 10 years rules, if you want to throw some light and educate us on the 10 years rules.
Thank you so much. Thank you everyone for once again joining us tonight to run this program or this show. Without you, we can't run the show. So we're always grateful that you guys join us to have this discussion on topical areas of the law. Tonight, obviously, as the host has just introduced the topic, I will discuss 3 things, the 10-year rule, the 20-year rule, those with exceptional circumstances who don't fall under any of this, how they can get their stay. Now, as the host has just pointed out, normally when we say 10-year lawful residence, we mean those who have lived here lawfully for 10 years. And as most of you are already aware, when you live here lawfully for 10 years, continuously, these 3 words are very important. 10 years, lawfully, continuously, then you are entitled to indefinite leave to remain, subject to fulfilling the other relevant requirements. So 10-year lawful residence is for those who have lived here lawfully, either on visit visa, student visa, workers permit visa, spouse visa. They could combine all these categories of visa which are valid. In fact, we'll go into the fact that some people who might even seek asylum and wait for about years, they also have this element of lawful residence. So when they combine all these years and it's cumulatively 10 years, then they will be entitled to make application of lawful residence, 10 years lawful residence.
All right, thank you very much. So are there any, absence that are permitted under the 10 years rules for this application? Are there any absence under that?
Yes. You see, when you look at the immigration rules, you find out that every route that you are relying on to make your application has quite distinct permissible absences or absences that are permitted. For example, if you look at it, the naturalization, we have permitted absences of 450 days. If you look at a 10-year rule, we have permitted absences of 540 days. This is quite important because if for whatever reason, throughout the 10 years, your cumulative absences from the UK is more than 540 days. And for those of you who are mathematicians, as I said, in Chi, it works out to 18 months. So if you go beyond that, then clearly, at what point you went behind that, then it should be considered as a break in your continuous residence. And There are also some absences, and some absences may be related to leave to remain, for example, when there are caps, and I'm sure we'll go into that as well so that people can be mindful of that.
All right, thank you very much, lawyer. Thank you. So when we talk about unlawful residence, because I know a lot of people might be thinking of what constitutes an unlawful residency. When you talk about that, what is actually the meaning of that for someone to be an unlawful resident?
Yes, if someone is unlawful resident, then it means that that person, in effect, is living here illegally. Is living here without any valid visa, under any of the immigration rules or the European regulations, or which is currently the Citizens' Right Act 2020.
All right. So talking about lawful, now we're going to talk about lawful. What makes somebody lawfully resident? What is the meaning of lawful residence in the UK? When we talk about that, what is the meaning of lawful residence?
Yes. As I said earlier, if you are a lawful resident, it means that you either have a visa, obviously those who are British or European citizens. In fact, these days, because we are out of the EU, you can even have an EU national who might be living here unlawfully because maybe they've not been able to apply for under the settlement scheme, or they've not been able to make successful application under it. So unlawful residents, as I've said, are those who don't have valid visa, or they had visas, or they have some form of leave which they have to renew. They eventually renewed it. It was refused. They made an appeal. The appeal right became exhaustive because perhaps they were unsuccessful. So somebody can be lawful residents, but eventually may become unlawful residents when their visa, for example, becomes invalid, revoked, or expires, and are not able to renew it.
Thank you very much, Leah. Before we continue, if you've just joined us, we're talking about the 10-year and the 20-year rules towards indefinite and exceptional circumstances where people could be granted indefinite leave to remain. This is what we're discussing, and lawyer has covered the Twi version on Tuesday. So tonight we're doing the English version. But before we continue, I would like to acknowledge a couple of people that have joined us on Facebook. And if you've got the link and you're listening to this program on radio, you can give me thumbs up, and I'll give you a shout out. I'll acknowledge you as well. So yes, thank you very much, our Facebook viewers. We have Obaya Pokia, that's Mami You is watching. Karen is watching. Karen is becoming a very usual viewer. Thank you very much, Karen, all the way from Ghana. But then I hope you benefit. And you know people in UK, and they're all going to benefit from this program. And Karen is saying, hi, Joe. Hi, Karen. I hope you're doing well. Always looking good. Thank you very much. I take inspiration and motivation from you. So, Jenna Edusei is watching. Christian Ajay says, good evening. Thank you very much. Hey, Christian Ajay, that is my number one DJ. Hey, DJ Craze Vibes. DJ, thank you very much for watching. Yeah, that's right. Yeah, thank you. And then also we have Jenna Edusei watching. Jenna says good evening. And of course, my main man, I'm for Tritano Sapon, Pi Stone, Big Stone. Congratulations once again. The Vim Day. I'm for the unbeatable Florent Prempeh College. I believe you all witness how we obviously demolished and we destroyed Presec during the finals of the Science and Maths quiz, the National Science and Maths quiz. Prempeh is a very good school, and sometimes people might be wondering why some people want to compete with us and they think they're going to go scot-free. No, it didn't happen like that. We actually, demonstrated our knowledge and how good we are during the competition. And I think the pre-seconders have learned their lesson. They will never come forward again to contest or compete with Prempeh College. Senior, thank you very much for the motivation. And then also we have Kofi Wizi. Kofi says, Thomas, you are preaching immigration issues better than I used to do self-la. Why, Kofi? Are you an immigration officer or are you a lawyer? Anyway, thank you very much. And then Tano says the prog is super. Thank you very much. And my regards to your princess, your wife. Yes, Big Stonewall, all the way in Holland, Amsterdam. Continue to support this program, and I know obviously people benefit from this. So please, I will entreat everyone to watch it. Obaya Apokuya says, good evening to you all, honorable men. Thanks for the good work you are doing. Thank you very much, Obaya Apokuya. Mami you all the way. And then Big Stone says, always enjoy it. Big Stone is watching and listening. Big Stone, thank you very much. I've already acknowledged you anyway. Thank you. So, viewers, we've got a very interesting topic that we're talking about tonight. Tonight we're talking about the 10 and 20 year long residence rules to indefinite leave to remain or exceptional circumstances as route to leave to remain. So we've got a 10 years, we've got a 20 years long resident rules, and then also there are some exceptional circumstances that people can benefit from that to get indefinite leave to remain in the UK. This is very important, and I've got lawyer here. I'm asking him a couple of questions. He's taking his time and giving us a very good explanation. So please invite people to and share the program for others to benefit from this educative program. I'm going to go back to lawyer, and of course we have a lot of questions for him. Lawyer, so I'm coming back to you. So is it possible to qualify for indefinite leave to remain under the 10 years rule if there are gaps in lawful residence? I know you've already touched the lawful residence, but I want you to put a little bit more ink into the gaps and direct it to the 10-year rules if it could still be possible. I want you to throw some more light into that for me, please.
Yes.
Thank you.
Yes, obviously the 10-year route is a quicker route for a lot of people, even if they are on certain categories of visas and they combine it together. But as I've said before, there are two issues there that people should always be mindful of. I've already mentioned absences. Absences are when people go abroad and stay there for over a period of time. I've already said that when people cumulatively spend more than 540 days abroad, then that could hinder the application. In fact, there is a case of Shan, very recent case this year, when someone spent just 500 or accumulated 543 absences. That application was refused because that person has spent just 543, just 3 days over the 540. He was refused. But the good news is that that case of Shan, which is a very recent case, have opened a door that these absences are now extended to 548 days because the upper tribunal confirmed that if you look at the 18 months, it's not all months that are 30 days. Some months are 31 days. So viewers should take note of these absences. These are not in the immigration guidance. But they are in the case law, and as you well know, we combine case law and guidance, so it's a very new case. Coming back to absences, again, if in a year you spend more than 180 days, then of course that could also hinder your process. But the gaps relates to people who are lawfully, but whenever they are doing their application, they are renewing it within the intervening period, they may allow it to expire before they send it to Home Office. By definition, that's what we call the gaps. So the gaps will be, let's say your visa is expiring at the 3rd of December, which is tomorrow, and then you make your application maybe 28th of December. So within the 3rd of December, when your visa has expired up to 28th of December, there have been a gap. Again, that gap we need to look at. If you look at the rules, before, if you accumulated any gap, or if there was any gap between 24th of November 2016 or before, up all the way to 24th of November 2016, then you'll be able to still apply for this lawful resident or indefinite leave to remain through the long residence, continuous residence, if those gaps are not more than 28 days. So if it's more than 28 days, then there is a problem. You might not be able to make application unless there are compelling reasons. Then after 24th of November 2016 onwards till date, it's only 14 days that are permissible. So if your visa expires more than 14 days, again, there is a problem. So people should take note of this, because these gaps can prevent people from being able to rely on the 10 years continuous lawful residence route for indefinite leave to remain.
All right, thank you very much, lawyer. So people should take very good note of this, because these gaps can cause a lot of problems. Let's educate ourselves. Let's make sure that we do everything to make sure that we don't leave any gap for them to base their decision on to refuse applications. Thank you very much, lawyer, for throwing some light into that direction, because I was quite confused with the gaps. I mean, I wasn't sure, how many days or how many months, obviously, that could, but you've given a very good briefing on that. Thank you. So, talking about this 10-year route, people under the 10-year parent route, can they also apply under the 10-year long route? Would that be possible?
Yes. The reason I'm discussing this is that this 10-year route, lawful continuous residence route, is quite advantageous. And the reason I say that is that you can combine all categories of visas. For there are some people who are here, they might be students, they might be able to do their degree for 3 years, they might do PhD, they will go on post-study visa, eventually they fall in love, they get married to a woman or a man, and then they also go on 2.5. So when they put everything together, they are entitled to make application if they have lived lawfully for 10 years. They are able to make application for indefinite leave to remain. For example, those on the parent route, for example, we always say that they are on 10 years parent route. But when you look at it critically, and I have represented a lot of these parents in these applications, you find out that when they say 10 years route to indefinite leave to remain, if I was doing the Twi language and I made mention of this, when the person makes that application, on subsequent renewal, that application sometimes can take about 6 months. Some will take about 4 months because finally decision is made to renew the application. So you realize that within the 4 renewals, in the intervening period of renewing the visas, each occasion, Home Office may hold their passport subject to decision being made for about 4 months, 5 months, 6 months. So cumulatively, within the intervening period, they might have accumulated about 24 months. So you realize that if they have renewed their visa for 3 times 7.5 months, and then you add cumulatively the other 24 months, which under the paragraph 3C of the 1971 Act, it extends one visa if one has leave to remain visa, puts in the application before the visa expires. Then throughout that visa is with Home Office, subject to decision or pending decision, that leave is considered to be lawful and therefore extend that person's leave. So if you put all these intervening months together, you realize that by the time you make your application for indefinite leave to remain under the same parent route, you would have spent about 12 years. People don't take note, but that is the reality. So the advantage of this 10 years lawful residence is that instead of continuing on that parent route, when you look at the first time you had your visa, let's say you had your first time you had your visa, this law came into place 9th of July 2012. So there are people which by next year, 2022 July, they would have been 10 years. But I trust you, most people by then will have their visa stay valid for 2 more years. So those people can allow on a 10 years lawful residence, and they will shorten the period they would have waited to renew their visa under that same route by taking a beginning of 10 years lawful residence.
All right. Thank you very much, Lawyer Thomas Beyebenwo from City Law Solicitors. So, viewers, if you are now listening to us, this program is proudly sponsored by City Law Solicitors. They've been our backbone from day one. And City Law is only the law firm that has brought media house like this. And of course, they have 24 hours radio that you can enjoy music and listen to various activities. Now, this program is live on our radio as well, City Media Radio. If you check on Modern Ghana, their broad section, you find City Media Radio is there, and I've shared it to most people. So if for some reasons you can't watch us live on Facebook or on YouTube, the radio is accessible. You can use that, and of course you benefit from this program as well. Thank you very much, Lawyer. Lawyer, people have been in this country for 14 years, and they've gone past the 10 years. Maybe they were not eligible to apply under the 10 years route. Is there any route for 14 years, for those who have been in the country for 14 years?
I'm sorry to say that when the changes were made on the 9th of July 2012, there used to be 14-year rule, but those changes that were brought in took away that route to indefinite leave to remain. So what we now have is a 20-year route. Previously, people could have lived here unlawfully for a combination of lawful and unlawful for 14 years, and they could have applied straight away for indefinite leave to remain. That route is no longer an option. Okay. Now they are only able to apply under the 20-year route.
All right, thank you, Lawyer. So people that probably made the application under the 14-year route, in that circumstances, what happens? I mean, the application is already made to Home Office, and now they've come out with a new law that 14-year route is no longer enforceable. So now, what will happen to those that made application prior to that?
Well, I would be surprised if anybody had made a application under the 14-year route. The reason being that this was changed since 2012. So from 2012 to date, I would be surprised if there will be any case that is still pending. Yeah, so there was nothing like that. And sometimes it's good to ask this question because some people still think that they can apply for indefinite leave to remain after 14 years or 20 years. I'm sure when we go through that, people will know that there have been a lot of significant changes. Yes.
All right, Lawyer. So let's talk about the 20-year route then, because this is a law that I think is in place, and people who have been in this country for 20 years can now make application. So when we talk about the 20-year route, what is that? What is the 20-year route?
Thank you. When we talk about the 20-year route, as I said, the 20-year rule will replace the 14-year rule. Obviously, the 20-year rule is there for people to make application after having lived here continuously. And the word here is continuously, but combination of either lawful or unlawful. So in this case, they don't need to show that they have been here lawfully. They can be here unlawfully. Or some people may have visa, it expires, they continue to live here. Or some didn't have visa at the point they had it, and then eventually maybe they couldn't renew for one reason or the other. So there are some people who just came in, they never had visa at all, and they also lived here continuously for 20 years. So normally the 20-year rule is there as a last resort for those who have not been able to do anything within the 20 years, or did something but along the line they could not continue under that part, and then they had to wait for the end of the 20 years so that they can be able to apply for leave to remain.
Thank you, Lawyer. Before we talk about what they need to do to make that application, I want you to explore or throw some light into what can prevent people from applying under the 20-year route. We will talk about what people need to bring or what they can do to get that. But before then, what can prevent people to apply or to qualify under the 20-year route?
Yes, there are two. In fact, it's quite sad that sometimes, even after people have lived here continuously for the 20 years unlawfully, they may still face some hindrance in terms of being able to make application under that route or under that category. And some of the difficulties or challenges will be either they are not able to evidence or show that they've lived here continuously for 20 years because they don't have proof of address, or they don't have anything to show that they are actually living here in this country. And then there is also a requirement under the suitability grant, which is section LTR 1.6 and then 1.4 or to 1.4.2. Realize that they have some requirements there in terms of people having been committed, who have committed offenses and have been imprisoned, and eventually they may pose a threat to the public good. It's a wide definition. So people who have criminal convictions, they might say that, well, they pose a threat to the public good, so because of that, they cannot give them that leave. So people have to be careful. But obviously, there is always a way around this using the relevant legal framework. So I'm sure I'll have opportunity to explain to people when they are in those situations what they can do.
All right, thank you, Lawyer. So let's say if somebody has been in the UK for 20 years and beyond, and unfortunately, the person hasn't got any documentation to prove that he's been in the UK, probably working with somebody's documents, which most people do anyway. But then the person has not had any criminal convictions or anything to indicate that he's not a good person, and has been working with somebody's documents. Is there any grounds or any reason, or is there anything the person can do to be eligible or to qualify for this 20 years route?
Yes. In fact, this is the main reason I'm doing this program today. Because gradually we are finding out that a lot of people have been here for 20 years, even more. And they are facing these challenges, which is they don't have something to show that they have been here for 20 years. One, because some of them, when they registered GP, maybe they use an uncle's name to register the GP. So they have been accessing NHS. This is sensitive, but I am entitled to say it because there is a case law which I'm going to discuss. I know it's quite sensitive, but I am discussing it so that people who are living in fear will then come out and exercise those rights and rely on the law to remedy their situations. Because I don't want people to stay in fear when the law supports the situation they find themselves in. So obviously those people, one, they may be accessing medical care, NHS medical care, under someone's name. Some of them are using people's documents to work. Some even with rent and other things, they use people's names to do it. And if you find yourself in that situation, what will you do if you have been here for 20 years? How are you going to make successful application if you find yourself in the category of people who have just described? The first thing you can do is that there is a new case law, which I was discussing it in Chi last time. And this is a case about one Mr. Sultan Mahmoud, who was using another guy called Ahmed documents to work. And he has used that document. I want to give a gist of that story so that people can understand that these things are known to the upper tribunal. And therefore, they should not live in fear if they are in those situations. They should come out, and there is a way out for them. So this guy, obviously born 1979, was using another person's document who was born in 1976, who is a British. He actually came into this country, I think, around 1996. So by the 14 year, I think around 2009, he made an application. And he made it clear.
Under the 14-year rule
Yes,
at that time?
He made it clear that he has been using someone's document to work for 10 years.
Mm.
And that he has been here for so and so period. And in fact, some people, when they are at work, they can even, the immigration officers come there, they encounter them, sometimes detain them, and eventually give them bail. So this guy was also once detained in that name. And the reason why I'm giving this story, I'm making it so that people, because I know what I'm saying fits someone's situation. And if you know anybody in that situation, let that person know that there is a way out for that person. So when this guy was encountered, obviously he had admitted that he was using that name to work. He had a bail, he was around for a while. When he made the application, and admitted that he has relied on those documents, he has worked here illegally for those period, Home Office refused the application and said that it is false representation.
Wow.
And the case went to the upper tribunal. The tribunal decision is quite superb.
Mm.
The tribunal decision was that if someone was here illegally, in any case, that person is here illegally, that is why he has to stay here for 20 years. Then the only thing that he needs to show is that he has lived here continuously for that 20 years. He claims he has lived here. And therefore, this man, having used that name to access NHS medical care and working, clearly shows that he has been living here continuously for that period. And therefore, that man should be granted the leave to remain under the 20-year rule. So if you are somebody who have found yourself in this situation, I want to assure you that there is a case very new, just summer last year, that will support your application. And sometimes when I was doing application for one of my clients, I think I'll be having issues. Sometimes when you check the immigration guidance, I love case laws, because case laws, when you are there in your armory, is a very strong weapon that they can use to demystify every situation. I found out that even when he was absent for a couple of days, and Home Office guidance said 540, the case of San said 548. So I saved my client. That application would have been refused.
Yeah.
But I know, obviously, it's all about how you can present the client's case. So this is an opportunity for people to take advantage. And I know a lot of people who have been here for 20 years, living in fear, they don't know what to do. They should come out. There is a way out. That's all I can say.
Thank you very much, Lawyer Thomas Beyebenwo from City Law Solicitors. Honestly speaking, I'm really impressed with what lawyer is doing and the good work that he's doing for the Ghanaian community and of course the African community as a whole. He's given a lot of briefing on the 10-year route, the 20-year route. People think they're still eligible to make application under the 14-year route. Lawyer says it's no longer in existence. You can't do that. And now we're talking about the 20-year route, which a lot of people have been in the UK without documents, and they living in fear. They know when they approach Home Office, they might be removed or deported. But then lawyer has given the assurance, and this is one thing that lawyers do. they base their cases on what has been discussed and won probably in the upper tribunals, as he's just given an example. So they normally bring cases, they mention the name, Nathaniel, blah, 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 Jessica, why. You know what I mean? They do all this, and then this is evidence, and they can base on that and say, look, you've done it for this person, so this is my client. In the same situation or category, he needs to be given that same opportunity. And this country, they go by that. So once there's a way through, or once somebody wins a case on one category, the next one, lawyers will push it and make sure that it becomes a loophole for everyone under the same eligibility or requirement to pass through. Thank you very much, lawyer, for this education. Of course, I'm going to acknowledge my viewers. Viewers mean a lot to me. And on the Facebook, I've got a lot of people more watching, which I need to acknowledge them. I've got my dear sister, Miss Anita Edu. Anita Edu, Mamiesi, is a discount shopper, and she's Avon executive, member as well. Her name on that is Anita's Avon VIP Group. It's a VIP group member. So if you want to order something from Anita, or if you want Anita to do shopping for you, as a discount shopper, she can go to the nitty-gritties, the root, and make sure that she get good deals for you. And I've witnessed that. I know a lot of people that she's done shopping for. So Anita is very good with the shopping, and very affordable as well. The email address is thediscountshopper@gmail.com. And Anita's WhatsApp number is 079 600 22058. I went to Ghana last time, and I was really amazed the shopping that she's done for a couple of people, and I saw it, and very cheap. She can do it all over the world. So wherever you are, make sure you get in touch with a discount shopper. It could be Avon materials or products, and any other friend as well. Anita is based in Northampton, so please make sure you contact Anita. And then also I want to wish my cousin Abel Ohene Akwe, Senior Abel, happy belated birthday. He celebrated his birthday yesterday. That was amazing. And he launched a very inspirational music. He launched his music, which is really, really good. I listened to it this morning, and I was so touched with it. The voice, the melody, everything. It was so good. Abel, he's been a fantastic boy anyway. So I know he's going to excel in everything that he does. And of course, he's proving that he's good and he's talented as well with the music that he's launched yesterday. Thank you very much, and happy birthday to you, my brother. We've got Kofi Wizzy. Kofi says, hey, Thomas, watching live from Grapevine, Texas. Wish you only launchy, and remember thy servant in the good old days. That's from Kofi Wizzy. Anita says, very educative. Thank you very much, Mame. That Queen is in Ghana. Good evening, bro. Good evening, that Queen. Thank you very much for watching. Eric Nyako, I'm watching you live, lawyer. Well done for the explanation. Thank you very much. Nana Poku Afriye Patterson, Ura is watching as well. Thank you very much, Ura. Thank you, Ura, for your support. Big ups MC Chaka and Lawyer Thomas. That's from Ura. Thank you. Big ups to you too for watching, and make sure you share for all your friends to benefit from this as well. Anita says, I will send recommendation through. I know a couple of people. Anita, this is what we're waiting for. We need to help and support ourselves. There's a lot of people that are eligible for indefinite now. They've been in this country for 20 years. They are approaching 20 years. I know people might be calling me, oh, Chaka, I've been here 19 years. Wait, when you get to 20 years, start gathering your documents, start getting evidence or whatever. When you get to 20 years, I'll refer you to lawyer. Make sure you clock the 20 years, and then of course we can make a referral. So, Chaka, when are you enrolling into law school? You will excel, pa. In fact, I wouldn't even struggle one bit. All my essays, everything will be done by a lawyer. Anyway, thank you very much. And I'll think about that anyway. Probably criminal law. Thanks, bro. Thank you, Anita. Ura is saying share. And then also, Bro Bernard. Big ups, MC Chaka and lawyer. Thank you very much. That is my original Akonta in Ghana. Akonta, thank you very much. I know you always listen and watch this program. God bless you. And I hope you're taking care of my sister and the family. May God richly bless you. I'll talk to you after the program. Thank you very much for the comment and sharing as well. So yeah, we have a lot to discuss. This route is very beneficial. A lot of people, they've been into trouble. They don't know what to do. But now this is the leeway for the 20 years. We know after the EU law or after the Brexit, there've been a lot of things going on in the background. People haven't been able to come to terms with whether they'll be eligible to get any indefinite or any stay in this country. But lawyer is opening the doors one by one. We've spoken about certain areas that you can still make application under the EU law. Now, lawyer is throwing lights on people that have been in this country for 20 years. And it's already talking about the 10-year lawful stay in the UK. Obviously, the route, the 20-year route is what we're discussing now. So, lawyer, I've got a question, and this question is in between the 20-year and the 10-year route. Do you want to go for a quick break, or are you okay to continue, please? I just don't want to make sure that you overwhelm me with questions. So I just want to make sure. Do you want to go for a quick commercial break, or you want to continue?
We can actually continue.
All right, thank you very much. Anyway, so yeah, so people have been in this country. They might not be eligible for the 10-year route or the 20-year route. Can they still make any successful application? Can that be possible?
Yes. I think that it's important to set out few stuff here, and I normally make sure that whenever I'm giving this advice on the platform, I go into details to ensure that people benefit. Now, clearly we've discussed the 10-year rule to indefinite leave to remain, the 20-year long residence rule to leave to remain. People must know that that leads to leave to remain, and then you subsequently on 10-year route to indefinite leave to remain. So you just mentioned that somebody has been here for maybe 19 years, 18 years. They are not yet 20 years. Probably they don't also fall under the 10-year rule because they have not been law before. Then we have to go into the immigration rule. And I'm going to rely on two areas of the legal framework. One is a case law, and the other one is the immigration rules itself. If you look at the immigration rule, paragraph 276 ADE, subsection 1, subsection 4, there is what they call the difficult or the obstacle route to integration. So what it means is that if people have exceptional circumstances that makes it difficult for them to integrate if they are sent back to their country of nationality, then those people are eligible to make applications even if they've not yet lived here continuously for 20 years. So somebody might have lived here for 16 years, 14 years, 11 years. The question is this person also entitled to make application? The answer is yes. And the reason I said this, I've already set out the immigration rule that makes provision for such applications. But going beyond that, this is why you need a good lawyer. The case of Pavan versus the Secretary of State, which is a Court of Appeal case, 2018, makes it clear that if you seek to rely on exceptional circumstances, then you must particularize those circumstances. So it means that you have opportunity to present a case that makes it quite compelling for you to be granted leave to remain, even though you don't meet the 20-year rule. For example, you might have a client who may have a stroke or partial stroke. You might have somebody who is sick. You might have somebody who, for one reason or the other, may have some mental problem. People get depression, remember, because most of these people, after having lived here for so many years, they may not even have family members back home. So there are other grounds, but it requires an expert who will be able to present very compelling circumstances on behalf of that client. And as I said, paragraph 276 ADD, section 1, subsection 4, makes it clear that those applications are allowed under the immigration rules. And I've also quoted the case of Parvin v. Secretary, very established new case law, Court of Appeal case law, also makes it clear that those applications can be made. So if you are one of those people who have exceptional circumstances, and MC Chaka, the good thing is that these applications are private life applications. They fall under the Article 8 of the European Convention. Okay. So they fall under the fee waiver. So people are entitled to make these applications. Obviously, if they can't pay, somebody who have exceptional circumstances obviously will not be able to pay for this fee. So they will get a fee waiver. So sometimes when I find out people not regularizing this, some people, they need to get accommodation from the council. They have social workers who are taking care of vulnerable adults. Some of them sometimes, I have friends who are social workers. In private, we discuss some of these issues. That they need to make this application so that these social workers can assess them.
Yeah.
And they don't do it because they think that, I have a client. Sometimes when you're dealing with a client and it's not up to 20 years, and you are very convinced that with the case law, the guidance, and everything that you have, you can do it. I don't know who is polluting these people. Don't do it. Please, it's possible, okay? We are using the law to support and assess people. It is very, very possible. And once those people are able to regularize their stay, they are able to assess these other ancillary benefits in terms of housing, medical care, and all that. So it's possible.
Thank you very much, lawyer. I mean, talking about these exceptional circumstances brings my mind to something. There was a time that I spoke to somebody, and a family member was seriously, in medical crisis. The person had was almost dying, and they said, because she hasn't got any documentation or any legal grounds to be in this country, they sent that person to Ghana. And I think few months after that, the person died. Yeah. You see, so it's very pathetic. Sometimes this is the reason why we do this program, to educate ourselves, to make sure that obviously we know what our rights could be, because there are so many grounds that we can make application to obtain our legal rights to be in this country. So thank you very much for training us light into that.
And if I can comment on the point you just made.
Yeah.
Now this particular person you have just described to me clearly was at the moribund stage of his life. And if you look at Article 3 of the European Convention, it is quite clear that such person is entitled to leave to remain merely on the basis of that medical condition.
You see?
So, sometimes I feel so sad that people don't have knowledge, they are not aware of some of these things. And a lot of people are suffering. And that is why City Law Society will take it upon ourselves to have such a platform so that people can be aware of their rights and then obviously rely on the law to remedy the situations and the hardships they are going through.
Yeah, it's really, really sad. Anyway, so let's move on. Uncle Jacob, Uncle, I know you're watching. Thank you very much. I know this is the first time that you're watching. My regards to Auntie, and please make sure you share for everyone to benefit from this program as well. So our Facebook Live is active, and I know viewers are really enjoying this particular topic that we've selected. So, lawyer, is there any update for half of life rules for under 25s? Yes. Is there any update on that, please?
Yes, obviously. There's been a lot of announcement on this, but it's always important to repeat this announcement because the more you make these announcements, the more people become aware, because these days everybody is busy. Yes, those who are between the ages of 18 and 24, or more than 18 but below 25, there is a conception that if they have been on that leave for 5 years already, then on their subsequent application for renewal, they are entitled to request for an indefinite leave to remain.
Okay.
So clearly, even though this was, I think, last 2 months that this concession came into force, people who are due for renewal obviously are entitled to make those applications. There are a few ambiguity and complications there. So I advise that if you want to make those applications, look for a good lawyer. If you don't have a lawyer, I would say that come to us, that we'll be able to help you.
Yeah, that is where obviously I need to sell lawyer for people to know his specialities and what he does. So this program, as I said earlier, is sponsored by City Law Solicitors. City Law Solicitors, they've come out with a very big studio, City Media. This is the studio. We've got the radio running as well. So now City Law Solicitors, they are based Unit 113 Barking Enterprise Center, number 50 Cambridge Road, Barking, Essex. And the postcode is IG118FG. If you need to contact them for any immigration issues, any employment law, family law, personal injuries, clinical negligence, commercial disputes and civil litigations, housing law, consumer law, media and entertainment law, please make sure that you contact them on their office number, which is 020-3355-0782. The number once again is 020-3355-0782. The reason why I'm not giving lawyers private number is because he's a very busy man, and sometimes it might not be out of disrespect or whatever, but then he might not be able to return your call because he get a lot of calls, sometimes about 100 and over, isn't it? So please call the office, and if you can't even get hold of lawyer, his learned colleagues, they are able to obviously listen to you and give you directions. So contact them on 020-3355-0782. City Law, they have proven record of resolving issues in all areas or aspects of law. So please make sure that you listen. I'm a living testimony. I've referred a lot of people to them, and they always come up with laughter. They're happy and obviously overwhelmed with the services they get from City Law. So please make sure you contact them for all your legal matters. And on that note, viewers, I'm going to open the phone lines. I'm going to open the phone lines because we need you to call the studio right now and ask questions in relation to what we have just discussed, or any other immigration law, or any other friend that might be baffling your mind, regardless of what area it is. The studio number now is 07932934518. I repeat, 07932934518. There's another one that is 0744033863. I'm doing it exactly the way the pastors how they do it, the radio stations. So 07440338623. These are the studio numbers, and I'm sure if you look at the bottom of the screen, it should be there. Please call us. We are in the studio. Lawyer is here, very equipped, very knowledgeable. He will answer all your questions, all your immigration questions. Whilst we're waiting for people to call, let me acknowledge and read some comments. So Mrs. Anita Edu says, knowledge is indeed power, of course, and she's giving a sign like that, power. Knowledge is power. Even the Bible says, for lack of knowledge, my people will perish. So knowledge is something that obviously we all need to make sure we acquire whilst living in this earth. Knowledge is power. Thank you very much, Anita. Jane Opoku. Jane says, God bless my lawyer. God bless you too, Jane. Jane says, God bless you, lawyer.
Amen. Amen.
Amen. Okay, Georgina Ajay says, hello, this is Georgina from Croydon. May God make you prosperous in your work. Amen.
Amen.
Thank you very much, Georgina from Croydon. Please make sure you share the good news for others to, of course, benefit from that. So, let me see. I've got my first caller. We've missed that call. Please call again, caller. My apologies. I've entered it. Please call again. We're still waiting for your calls. I've missed that call. I think it's a call from. There we go. Yeah. Hello. Good evening. You're welcome to City Media. My name is MC Chaka. How can I help you?
Good evening, my brother.
Yeah. Sorry, I can hear you now. Go on.
I'm George. Yeah, I'm calling from London, Northwest.
Northwest London. Which area?
Brent Cross.
Oh, okay, Brent Cross. All right. How are you doing this evening?
Oh, good. I have a question for lawyer.
Please go ahead. Go ahead with the question.
Yeah, my question is, I just arrived from Ghana almost a month ago. So how do I go by the regulations in this country so that I can stay here for the rest of my life?
Okay, that's a very good question.
Let me stay there because it's a very broad question. I need to.
Please don't have. Lawyer might ask you a couple of top up questions to ascertain the rationale behind the whole thing. So please.
Yeah, so you came in as a visitor or on a visitor?
A visitor, yeah.
Okay, on a visit visa. Okay.
Yeah.
Clearly, if you come into this country with a visit visa and you want to stay here longer, we've just discussed the 10-year lawful resident. We discussed the 20 years unlawful residence. But of course, if for whatever reason you are able to find yourself, I'm sure from your voice you're a very handsome man, you are able to find yourself a wife or a partner who has younger children under 18. Last time we discussed the non-biological
parent.
So if you are playing a role in that child's life whose father is absent, and of course you should be able to regularize your stay from there. If for whatever reason you are able to, if you had a partner and she became pregnant and had a child for you, and make sure that whoever that partner is have indefinite remain or British, because it's not everybody that can have a child that will have be automatic British. And of course, you being the father, you can also regularize your stay from there and apply under the parent route. Other than that, you may have to stay a bit longer.
Lawyer, before you go, so last time you spoke about people still making application under the EEC law as well. So if, for instance, he finds someone who probably is part of the EU, would there still be any route for him to make an application?
It is almost too late because remember the late applications only cover those who were married or formed their relationship before December 2020.
All right.
So currently, if he forms a relationship with the EU citizen who is living here lawfully, which has either indefinite or limited leave to remain, which is a pre-settled status, then if they got married now, he has to go back to Ghana and apply and come back. Unless that person has younger children. If he has a younger children under 18, then he can
I have a follow-up question, please. I have a follow-up question.
Okay, go ahead with that, please.
My question is so far as I just came, and there may be somebody who too maybe may need a husband. For that, is it applicable?
Yes, as I've said, if you become a husband, then you have two options. If the lady you are married to has younger children under 18, then you can make the application here in this country. You don't have to go back. And then you can also make the application on the basis that you don't have to meet certain requirements like financial requirements and all those stuff. But if you doesn't have younger children under 18, then obviously you'll be able to marry here because no law stops you from doing that. But you have to go back to Ghana or wherever you are coming from and make the application to come back in because of your immigration status, because the visa doesn't allow you to make spouse application in country.
I'm coming from Sierra Leone.
Sierra Leone, okay.
All right.
So you have to go back probably and then apply and come in. But if you want to do that, please seek proper advice because when you are going back, you need your spouse need to fulfill financial requirement. You need to do English, tuberculosis, and certain accommodation requirements as well. So don't say that one lawyer said that I can just go home and then apply and come back in. There are requirements to satisfy for you to come back in. So please seek proper advice. And if you need us to help us, you can pick our phone line on the screen. Okay?
Okay. All right. Thank you very much for your question and for calling as well.
Thank you.
If any issues or anything, contact the office number that I gave. I will repeat the office number anyway. So thank you very much for your call. Bye bye.
I'm following you on the program, so surely.
Thank you. And make sure you share for others to obviously benefit from that as well.
All right. Thank you.
All right. Great. Thank you. Bye bye. Bye. All right. So that was the first call. Have you had another call on this one? Yeah. So phone lines are still open. Viewers, please make sure you call, and then I'm going to give lawyer 2 minutes to wrap up. But before then, let me acknowledge a couple of people. Gabriel Banankori says, many thanks for the knowledge that you have given us this evening. Thank you very much, Gabriel. Miss Anita is laughing. Oh, what? I mean, these emoji signs, I was struggling to identify them. I don't know whether it's laughter or it's thumbs up or but I know there's an emoji sign. And Charles Soso is watching. Charles Soso and Ajay Yeboah is watching. Thank you very much. I mean, I'm really impressed with the number, and of course, people listening to us. Mr. Leboko and his wife, all the way from Belgium, they listening to us on the radio version. So thank you all for patronizing, and of course, my cousin Yanna Kwesiapia listening to us all the way in Ghana. I can see big ups to you. Thank you very much for being part of this program. City Law is bringing a family, an extensive family, a community that we all need to come together to support ourselves. The only people that can help us is ourselves. We all need to come together. And as they say, unity is something that will make us strong. So please make sure you share for people to benefit. Big ups to you, Cornelia. I've not seen you today, wherever you are. I know you watched the preview of this one. Make sure you watch it. Anyway, thank you very much, Cornelia, and I hope you're doing very well. So, lawyer, we've spoken. I know you've done a lot tonight. You've spoken a lot. You've given us overview on the 10 years legal long stay route, the 20 years route. You've clarified the 14 years route. You've identified exceptional circumstances. I want you to, for the benefit of those who probably might have not started or who have just joined us, can you please, in summary, let's say under 2 minutes, go through what you've just said or what you've gone through in under 2 minutes, please. Thank you.
First of all, I want to thank everyone for their infringing support, for always being there. Shout out to those listening to the radio. We are so thoughtful of you. We know some of you might be working City Media Radio or listening to City Media Radio. this is the only firm that brings to you radio station that you can enjoy free legal advice. So please continue to enjoy the radio and share it around. Now, back to what we discussed tonight. Tonight we've discussed three distinct areas that you can rely on to get either your indefinite or leave to remain. The first one, I discussed the 10 years continuous lawful resident. I explained that people can combine various categories of visas as long as it's cumulatively 10 years and it's lawful and continuous, they can apply for indefinite leave to remain. And I said that they have to be watchful of what they call absences and gaps. With absences, I said that for the whole 10 years, your cumulative absences should not be more than 540 days, which works out to 18 months. That's Home Office guidance. I have gone beyond that and said that there is a case of Shan, which is a Chinese girl who made application, had 543 days. Home Office refused the application. Upper Tribunal has confirmed that, in actual fact, months are sometimes 31 days, not 30 days. So therefore, that 18 months should rather be 548 days. Home Office guidance currently have not been updated. So if you're a lawyer and you're representing your client, make sure you take notes of this. Also, I've also said that gaps are also hindrances. So before 2016, November 24th, you should ensure that your gap is not more than 28 days. And I said that gap is when, for example, during the intervening period of renewing your visa, maybe your visa expires a day or two before you post it to Home Office or submit your application. If that goes beyond 28 days, and that 28 days occurred before 24th of November 2016, then you are likely not to be eligible to apply under the 10 years lawful resident. And I also said that after 24th of November 2016 onwards to the date, if it's more than 14 days, again, you will be likely to be excluded from relying on the 10 years lawful continuous residence, subject to compelling circumstances. So that's about the 10-year rule. Obviously, people need to do their B1 test and then their life in UK in order to make successful application for indefinite leave to remain. 20-year rule, I said that there is no more 14-year rule because that was abolished on the 9th of July 2012. So I'm sure next year we'll be celebrating a decade anniversary of that. So that is gone. Now we have 20-year rule. And my focus is on the 20-year rule because people live here continuously for 20 years. They have obviously lived here either lawfully, unlawfully, combined, or continuously, unlawfully. And then they have difficulties making application because the immigration rules requires them, again, 276A, requires them to show that they have lived here continuously. So they need to prove of address and some other documentation to show that they have been living here. Most people do not have these documents. And why? Why? Because this is sensitive, but it's a case law. So I can say it openly. I'm entitled to do that. Because they are using people's documents to work, because they are obviously sometimes using people's documents to access medical care. And if you are in that situation, you may not be able to prove that you have anything in your name. But under the case of Mahmoud Sultan, which is a case, upper tribunal case, promulgated just last year, 2020, very new case, it makes it clear that even if you are using someone's documents, I know one time I said it on Hot FM, people were saying, hey, lawyer, I don't know cancer. Please, I don't talk anyhow. Whenever I come here, I say facts, not fiction. So it is clear that if you are in that situation, even if you are using somebody's documents to work, you are using somebody's documents to assess medical care, all that you need to do is to show that you have been here continuously for 20 years. Some of you may be working at the workplaces you were once encountered using that person's name to work, which means the Home Office are already aware that that is the document you are using to work. So if you, tomorrow you are making an application and say that, look, I have used this document to work continuously for 10 years, and these are my evidence. Nothing stops you from relying on those to make application, because this is established case law. And as lawyers, we know that this is a very strong weapon in our armory. It's like going to the war front with your missiles. Yes. So I also said that, with jokes, I also said that those who don't meet these two, satisfy these two categories, or don't fall under these two categories, what is the way forward for them? One, Mr. Nikwe made mention of something which touched my heart. That one I didn't discuss, but I want people to know that we have what they call Article 3 grounds for making application. What those who have serious medical conditions that are at the more advanced stage of their life, they are entitled to make application on those grounds. But that was not the substantive area for my discussion. The other area which people who don't fall within this category, which is those who have exceptional circumstances. And I said that under the immigration rule, paragraph 276 ADE, section 1, subsection 4, it makes it clear that those people are entitled to also make applications. So if you know somebody who has exceptional circumstances, who have not been here for up to 20 years, less than 20 years, but they have those conditions, they need to speak to a lawyer because they are entitled to make application. And I also backed it up with a case of Pavan versus the Secretary of State, Court of Appeal case 2018. It makes it clear that if you have those conditions, then you need to particularize your exceptional circumstances that makes reintegration, or if you are returned to your country of nationality, quite difficult or present an insurmountable difficult. This is where you need a good lawyer to be able to particularize those circumstances or representations for you. So that's what we discussed today. If you know anybody in this category, don't hesitate to refer that person. We are here to help.
Lawyer, we've got another question from Amy Brown Sugar. He says, what about asylum seekers for 20 years? Is there any route for them as well, asylum seekers for 20 years?
But asylum seekers have a very distinct advantage. Obviously, anybody who have been here for 20 years, I've already said that they are entitled to apply for leave to remain. But this is what I want people to take note of. If you are an asylum seeker, if, for example, you were a student, and then being a student for years, maybe you are lesbian or gay, you cannot go back to where you are coming from, you may be entitled to seek asylum. If you seek asylum, it might take years before your application is concluded or decision is made. That waiting period, again, paragraph 3C right applies because you had the leave before you sought the asylum. So throughout that period, when you don't even have any leave to remain, it's lawful residence. Therefore, people, if their condition change, they are entitled to also apply under the
asylum,
under the 10-year continuous lawful residence. If for whatever reason, whilst they are waiting for the asylum decision, they change their circumstances. So I want people to take very good note. So asylum seekers have very distinct advantage. They are, when you look at the rules, they are the only category of people that, whilst there are some other ones will be illegal, they can rely on that particular duration as continuous lawful residence. And then
apply for the 10-year route.
10-year route, because when they, let's say they had a leave to remain and made application or sought asylum, whilst they are waiting, these days, those applications might take a year, 2, 3, doesn't matter. They may say you are not entitled to work, but that waiting period is lawful under the lawful residence rule. If you look at 276 So that person doesn't have to wait for 20 years. Maybe he might have to seek proper advice. He might even put in a fresh claim.
All right.
Circumstances might change and all that. Yes.
Okay. So Amy Brown Sugar, I hope your question has been answered. Being an asylum seeker, or if you know anybody, or if you've asked this question on behalf of someone, then I think the explanation has well been given by solicitor or lawyer Thomas Beyebenwo that this is an opportunity for you to obviously, because it's a legal route anyway, so you can be eligible for even the 10 years and you don't have to wait for the 20-year route. Thank you very much, lawyer, for that. Last question from Shelley. Shelley wants to find out, nurses in Ghana, is there any route for them to make application to come to this country to practice, nurses in Ghana?
Yes, I think I've done this person can still follow me on Facebook. I've done a detailed topic on this sponsorship scale up and the scale worker. I did this, I think, somewhere in August. So it's still there. But if you don't have time to work, yes, it is true. Nurses fall under a shortage list.
Mm-hmm.
So you just have to go to the various websites, look for a job. Once you have been employed, that particular employer is required to have what they call a sponsorship license.
Mm.
So if they have that license, they will be able to issue what they call a certificate of license to you. So that card will allow you to be able to use it. It's just an electronic certificate that shows your name, date of birth, and all that, and you can use it to make the application to come in here.
Yeah, lawyer. So that means those ones are going to be with the care homes and stuff like that, because talking about NHS, I doubt if they'll be able to grant that for them.
No, NHS have license. In fact, they are public bodies. NHS form part of the public bodies, so they also have license.
So nurses in Ghana, especially those that have got degree, can apply under the route through the NHS.
Of course, yes.
All right.
They can apply straight away. Yes.
Okay.
They can apply. So people should take note. Sometimes people call me. I already have so much I'm doing. I can't go to the website to go and look for vacancies for people. But if people get those vacancies, they get the employment. Some of the employers, they even assist in making the application.
Oh, okay.
But if they cannot assist them, you call us. We will assist you to make those applications.
All right.
But the starting point is getting the job offer.
Yeah.
And then from there, you'll be getting the certificate of the licenses, and then you'll be able to apply and come in.
Thank you very much, lawyer Thomas Beyebenwo from City Law Solicitors. Viewers and listeners, I know you've been blessed tonight. I know it's been very interesting and educative. Lawyer has taken his time to go through the 10 years route, the 20 years route, and exceptional circumstances to apply for leave to remain in the UK. And for those of you that came with comments, thank you very much. Katie Jumo, thank you very much for watching. Anita. And Amy says, thank you very much, lawyer. So viewers, it's been very, involving. Thank you for patronizing. This is what we're looking for. If we come here and we start talking and we don't get any response, then we might think we're talking to ourselves. But then if you patronize and make sure that you share for others to benefit, that is where we know we're moving forward. So thank you for being part of this educative community or program that we've set to you, or that we bring to you every Thursdays and Tuesdays. So this is where I'll call it there. I'm dropping the curtain right now. It's been very educative, very insightful, and we say thank you very much to City Law Solicitors, most especially lawyer Thomas Beyebenwo, for taking his time to go through and educate us on all these legal areas. Thank you very much, lawyer. Next week, Tuesday, we come with another interesting topic. So please make sure that you keep that in your diary. From 8:30, we will be back. Thank you very much and have a blessed evening. Thank you.